So we jump back into Richard Morgan Casey's testimony to the Post Office Horizon IT inquiry, and he's being questioned by core participants. And it's put to him that Stephen Dilley, who was his instructing solicitor, decided not to disclose the fact that the Horizon Helpdesk was receiving 12 to 15,000 calls every single month. He decided not to disclose either the volume nor the content of these calls to Mr. Castleton because they were worried that they would overwhelm him and that they might make him upset. So it seems that evidence which on the face of it, which would seem to support Mr. Castleton's position that there were horrendous problems with the Horizon system that one might say would have been ordinarily disclosable, are actually being withheld to help the defendant pastorally. I feel that he would have much preferred to have received the documents and received the help that he was entitled to, or shall we say the disclosure he's entitled to legally, and let him consider his own welfare on that regard for himself. Let's jump into the inquiry.
Now, I'd like you to help me, please, because, of course, I don't know if you were watching Mr. Dilley's evidence yesterday.
I saw part of it, but not all of it.
Have you read it subsequently?
No.
No. You may not have been present when this was going on, but the Post Office, he told us, was receiving 12,000 to 15,000 calls to the Horizon System Helpdesk per month, telephone calls from subpostmasters about defects and technical problems with the Horizon system, and Mr. Dilley decided that he wouldn't disclose these calls, neither generally as to volume nor specifically as to content, to Mr. Castleton, because at one point he thought that it might overwhelm Mr. Castleton in a sort of benevolent and pastoral way.
How kind of them. We'll hide some evidence because it might be distressing to you. The fact of it might be evidence that supports your case is totally nothing to do with the reason why we won't pass that on.
And on another occasion, because it was going to cost, in fact, £3,000 to collate them. Did you hear that evidence?
No, I didn't.
No. Now, having been informed of that evidence, may I ask you, and I mean no disrespect, Mr. Morgan, were you involved in that decision?
No.
No. Should you not have been consulted before such a decision was actioned by Mr. Dilley?
Look, at the end of the day, the relationship between solicitors and counsel is a matter of instructions and action on instructions. I was not instructed by solicitors in relation to disclosure. Simple as that.
But they're hiding evidence from you. Surely that would make you angry now, frustrated, upset, aboard, something.
Like to have been instructed to give your review on that somewhat momentous decision by your instructing solicitor?
I don't think counsel ever likes to be instructed on disclosure issues, but if one is instructed on disclosure issues, then one examines each individual document against the specific requirements of the disclosure order made by the court.
Would you agree with the decision that Mr. Dilley made?
I don't know. I haven't read the call logs.
So may I take it, therefore, that, and this is your opportunity to give your considered view, that...
Well, it's not my opportunity to give a considered view because I haven't seen the call logs.
Right. Well, let us move on. Do you think you were being kept at a distance from disclosure decisions by those instructing you?
I have no idea because I don't know what the disclosure decisions were or taken in what context. All I know is that Post Office Limited had instructed Bond Pierce and Mr. Castleton had instructed his own solicitors. And as is usual in litigation, solicitors had gone through the disclosure exercise. If there were perceived to be deficiencies, then there would be correspondence between them. And if necessary or appropriate, orders for specific disclosure or further disclosure. I was not involved in any of that at all.
Thank you, Ms. Morgan.
Is there actually something in the disclosure rules that says if you are concerned pastorally of the welfare of the defendant in a case, you shouldn't pass on documents that would ordinarily be seen as disclosable for fear of upsetting them or overwhelming them or providing them too much evidence? That would seem to be highly unlikely to me.
But just returning to the questions that were put to you by Mr. Beer, counsel to the inquiry. You asked a lot of questions, but it seems that answers came there none. Would that be your recollection now about disclosure?
About disclosure?
Yes, the questions that you asked about the integrity of the system, about remote access.
Well, that's not disclosure. That's some questions about what's actually going on. Disclosure I take to be disclosure of documents. Disclosure is a disclosure process. Disclosure of information about the case in relation to specific inquiries about Fujitsu, yes, I'd accept that I asked a large number of questions. I sought to ensure that the original equipment was maintained and steps were taken to preserve the software, but I didn't get anything after that. Nobody came back to me and said, well, what should we do now?
And so I ask you, therefore, did that set any alarm bell or did that fly any red flag?
No, because in the ordinary course of litigation, if there are disputes between the parties about particular procedural steps, then those are raised in correspondence between solicitors, and if they're not answered, then they're taken before the court at the CMC or PTR.
Right. Now, just dealing with that, you were saying that those were questions about the evidence in the case, but if you had got the answers, yes, they do have the ability to insert transactions without anybody knowing the fact that they can do that. That obviously would have been patently disclosable, would it not?
I certainly wouldn't have been able to run a case contrary to it. Disclosable.
You couldn't run a case if that was in your knowledge. You would have had to have considered your position.
Yes, exactly.
Exactly. So, let me just ask you, please, now, it's the time of trial. You're about to give your opening, or you've just given your opening, and we saw it, again, no need to put it up on the screen, it's been a long day, POL 000070126. You saw the attendance note of Mandy Talbot and the issue about Falkirk, and it's the 6th of December 2006. You've seen it. By all means, if you would like to see it again.
I'm quite happy I can remember it.
You can remember it. And you were saying, you are reported, forgive me, Mr. Morgan, RM saying he was concerned about whether we have to give disclosure of this fact. He thought probably yes, but wanted to find out if the judge thought it was relevant. RM was prepared to put off the decision on this until after his opening. RM asked Mandy Talbot to get some definitive answers from Fujitsu. RM saying that we may finish in court by lunchtime tomorrow. Falkirk, that was the calendar square bug. And if I recall your evidence correctly, you were not certain that your solicitors disclosed that to Mr. Castleton.
Yes.
It appears, does it not, that it arose in this way, that Mr. Castleton was tentatively putting his case about a post office, and then it was immediately understood and recognised by Mrs. Chambers that that was the Falkirk branch, the Calendar Square. Correct?
I think so.
Yes, it's in the judgment.
Yeah, fine.
It's in the judgment. It's paragraph, I think, 23 of the judgment. So it arose, as it were, ex improviso, purely serendipitously and by chance, that Mr. Castleton asked that tentative question and then that was revealed. Correct?
Apparently so, yes.
It's hardly ideal, is it?
Trials are hardly ideal. No, you're absolutely right. Things crop up that you have absolutely no idea about as counsel. Somebody just doesn't bother to tell you.
And similarly, the Tivoli logs arose for the first time in the course of Mrs. Chambers' evidence, and she had to be recalled, didn't she?
Mr. Castleton asked for her to be recalled, and she was recalled. I think somebody else was as well, wasn't they?
Yes. Ruth Skinner, or Simpson, forgive me. Ruth.
I can't remember, but I
Yes.
seem to remember there were two.
And he tried.
So interestingly, it's like he might not have received direct answers nor chased them up to the questions he was asking, but evidence was falling in his lap, maybe at an inopportune time for the Post Office's case, about various issues and various bugs coming up during the trial. Surely that must make you worry and maybe remind you of the questions that you previously asked and think, I need to dig into this because this could fatally undermine the case that I'm trying to build here.
Tried to cross-examine her and you objected to the cross-examination?
Quite possibly, yes.
Yes.